Madam Deputy Registrar, would you please call the matter?
Thank you, President Saunders. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Belize, hearing of the appeal in BZCV number 1 of 2022 between Hillaire Sears and Parole Board, the Minister of National Security, and the Attorney General. The members of this morning's panel are Mr. Justice Saunders, President and Presiding Judge.
Good morning, everyone.
Mr. Justice Witt.
Good morning, Council.
Mr. Justice Anderson.
Good morning, Council.
Madam Justice Rochnut-Lee.
Good morning, everyone.
And Mr. Justice Burgess.
Good morning, Council.
May we have the appearances, please? Thank you.
Good morning. May it please you, Your Honors, Leslie Mendes, appearing alongside Hector Guerra for the appellants.
Yes, morning again, Council.
Good morning. If it pleases you, Your Honor, Samantha Matut Tucker on behalf of the respondents, the Parole Board, the Minister of National Security, as well as the Attorney General of Belize.
Yes, good morning again, Ms. Tucker. Ms. Mendes, are you ready?
Yes, Your Honors. Thank you. May it please you. Your Honors, we have provided written submissions to the court as well as a speaking note, which we, by and large, intend to follow in our oral submissions. Certainly, I don't intend to just read or go through everything that we have submitted in our written submissions, but I would like to highlight our main points. And of course, I'll make myself available to answer any questions that your honors may have. Your Honors, the principal question before this court is really whether, yes?
Ms. Mendes, before you go into your arguments, could you provide us with some factual information? For example, we know that Mr. Sears has been convicted for manslaughter in 2002. Could you tell us if he had, before that, if he was in pretrial detention? Since when? That is something we would want to know. Since when? Was that taken into account when the 25 years was imposed on him? Another question is, either for you or Ms. Matut, but anyway, those are questions I think we would want to have an answer to. Whether there is the possibility of remission in the system of Belize, whether there is a possibility of remission even in the case of a revoked parole, that kind of factual information we would like to have. I think there's other things that we want to know, but when you get to them, we will probably ask that. But could you give us a broad oversight of this of these questions?
Your Honors, I will confess I was not counsel in the matter, in the criminal matter. I do remember reviewing the file and noting that he was sentenced before the Court of Appeal. I am assuming that his pretrial detention was taken into account, but unfortunately, I do not have those particulars with me, but I can definitely provide that to the court. I can provide that to the court at a later time, Your Honors.
Yes, never forget however important the questions are, we still need to know simply the facts behind it. So we would want to get that information, if not from you, then from Ms. Matut. But okay, please continue.
Just to follow on from what my brother asked you, Ms. Mendes, can you tell us when it is that your client is due to be released on the present scenario? When would his sentence be served?
His sentence would be served His sentence would be served, Your Honors, in I believe 26.
Is that with or without remission?
That would be without remission, Your Honors.
Is remission still a possibility?
I must confess I'm not in a position to answer that, Your Honors, just considering that that wasn't the main. I'm not too sure. I'm not too sure. I don't know if my learned friend perhaps would have some information on that.
Ms. Matuk Tucker, are you in a position to assist?
Unfortunately, Madam Justice, I am not in a position to provide any facts in regard to the remission.
Thank you. Ms. Mendez, you mentioned in answer to my brother, Justice Witt, that he was sentenced by the Court of Appeal.
Mm-hmm.
What was the position in the Supreme Court?
Your Honors,
was he sentenced?
I will have to apologize. The underlying claim, I just do not have sufficient information for. I do remember reviewing the file some time ago. But of course, these are all sort of like factual things that I can certainly present to the court at a later time, just to show a bit of the background about the underlying claim. Sorry, about the underlying offense. But no, I don't have that information. I came to the case. I was not the one that advocated for him.
No, I believe we understand that. It's just that for myself, I wanted to know, was he serving a sentence of some other years prior to the Court of Appeals saying 25 years, and therefore had he been detained before that time? I think those are some of the things that my brother Justice Witt raised, and I do believe I'd be interested to know. So don't just take us back to 2002, but if you could give us some history prior to that. Thank you very much.
Okay, all right. So is it that Your Honors would be interested in his antecedents report, or how he came to be detained?
You mean for the initial crime, the offense?
Yes. Sorry, Your Honors, I'm having some difficulty here. If you could just give me 1 second.
I'm not sure that we were interested in that, but I do know that what I would be interested in, subject to what my brothers have to say, would be the date of his conviction, in the Supreme Court, what he was sentenced for, and when was he first in custody. If there are other things, my brothers would certainly join in. Thank you.
Yes, certainly, Your Honors. I could certainly provide that information by the end of day to your Honors.
And of course, his release date. If nothing else happens, when is he due to be released from prison?
He's due to be released in 2022.
Well, since
2020 in 27, 5 more years, Your Honors.
Yes, but since that is bound up with the question of remission, perhaps when you're providing the other factual information, you could also provide that bit then, yeah?
Yes, I can certainly provide the position with respect to remission.
Okay.
And I can do so by the end of the day, Your Honors. Our focus has really been on looking at the decision to revoke his parole, and that really has been the main contention of the parties before the lower courts. May I proceed with my submissions, Your Honors?
Yes, please, by all means.
All right. As indicated, Your Honors, the principal question before this court is whether the Court of Appeal was right in upholding the decision of the Supreme Court. to dismiss the appellant's constitutional claim on the basis that the appellant ought to have instituted claims in judicial review, false imprisonment, and under the Constitution. The lower courts both adopted the position that because the claim included a challenge to the decision of the Parole Board, and that would in effect be seeking a quashing order, the appellant was obliged to file judicial review proceedings. The appellants respectfully submit, Your Honors, that in this approach, the court was wrong. Your Honors, I'm so sorry, but I'm having some difficulty here. May I please be given 1 minute?
Yes, we are hearing you just fine.
My apologies, Your Honors. I know that you mentioned that you were hearing me, but I'm hearing something in the outside, so I went to see what it was. But thank you so much, obliged. So there is the appellant's main position, Your Honors, is that the court was wrong in its approach, in focusing on the decision and in focusing on the effect that this would invariably be quashing the decision of the court. And this is because we say that fundamentally this was a claim that warranted the constitutional intervention because it was by its nature really one that involved a constitutional right. At its core, the claim was really one about the protection of the right to liberty. And so that when we spoke about the protection of the law, for instance, and how that right interacted in these circumstances, what we are talking about is a claim about the manner, the procedure in which the right might be limited and the conditions under which that right might be limited. So that we say that undue weight was placed on the bare administrative character of the decision and the particular relief being sought instead of looking at the content of the claim itself, which, as I have mentioned, we say did warrant constitutional scrutiny, considering the content of the claim and the substance of the allegations that were made.
Ms. Mendes, are you saying that judicial review would not have been a proper way to tackle this, or are you saying it would also have been a way to tackle this, but it doesn't exclude a constitutional motion?
Yeah, Your Honors, I do think certainly that judicial review would have been an appropriate way of allowing the court to look at this. And in fact, if we see some of the other cases, we do see that decisions of this similar nature have been challenged through judicial review proceedings. But we also say that in these circumstances, considering the other associated claims that were made, really it was a constitutional claim that in our view was more convenient. And we also want to bring to the attention of the court that at the time, at least we were not under the previous rules, judicial review was excluded. Under the previous prison rules under which this decision was made, judicial review was excluded from being used to challenge a parole decision.
And where can we find that it was excluded?
That would have been in Rule 27. That is Rule, Previa Indulgence. Rule 276. I can find it. Yeah, that would have been Rule 267. Paragraph 7, Your Honors. And in fact, in your decision, in Gregory August, Your Honors, there's a footnote that also makes note of the fact that that has been a change that has been brought about by the new Parole Act. So that in those circumstances, we say that whether recourse was available for judicial review was in fact questionable. I don't
have it in front of me, Ms. Mendez, but I seem to recall that paragraph 7 deals with a case where the board rejects the application for parole. As I said, I don't have it. Yes.
It says to refuse to grant parole. If your lordships can go just very quickly, just because but if at page 973 of the record, in the footnote, sorry, but it also says to recall a parolee or to revoke granting such parole. So it was encompassed under that sort of ouster clause with respect to judicial review. So it was not very clear that judicial review was even available. But even if it was available, I think that the point is still holds, which is that this particular claim, really the nature of it was one that engaged the Constitution. And even if it had come via judicial review proceedings, it was the very same arguments that would have been made to the court, because substantively what we're arguing and what really concerns this case is the manner in which the right to liberty has been limited and it has been breached. And so we say that the court's approach, it adopted an unduly restrictive approach to what is otherwise has been recognized as a rather flexible and wide jurisdiction that the court is vested with under the Constitution, and that has been well established in the jurisprudence before this court. We also say that the authorities that my learned friend has relied on are distinguishable to the case before the court, precisely because this case directly engages a constitutional right. If we look at Harikessoon, Your Honors, in Harikessoon, which is a case that also the lower courts relied heavily on, one of the reasons why the court ruled in the way that it did was because it specifically recognized that the right of the holder of a public office in that case not to be transferred against his will from one place to another could not be or is not a right recognized as a human right or as a fundamental or one as a fundamental freedom as specified. And so that was one of the critical reasons why the court also found that in that case, what we did see was claims that have been molded or contrived into constitutional breaches when that really was not the main concern or what was manifestly the nature of the case. And so it's on that basis that we say that these cases are distinguishable. And in fact, in the findings, or at least in the jurisprudence, what we see is that these cases also make very clear that the principal reason why courts have cautioned against the misuse of the constitutional jurisdiction, the principal mischief is that they want to deter frivolous or vexatious or contrived constitutional breaches. But they have also been very clear that bona fide breaches, however, ought not to be discouraged. And as we set out in our submissions, Your Honors, we say that this was not at all a case that was speaking to or that has brought to the fore trivial breaches. In fact, we have an uncontested 55-day pre-revocation detention period, which has not been, for which the respondents have not provided any legal basis, for which we do not find that there is any legal basis that would have authorized the prison guards to have detained him for that long prior to the decision to revoke. We also have the revocation of parole, and it's also not contested that the appellant was not given an opportunity to make representations before that decision was made. And we do say that there are also very specific uncontested allegations with respect to the undignified conditions within which the appellant was subjected to. So the claim is not at all one that is contrived or frivolous in a manner that would attract the approach that has been laid out by the submissions that my learned friend has brought to the court. In fact, we say that it is the nexus between the protection of the law and the core right to liberty that we say that it's the approach in the Observer publication limited and Matthew that we say is more appropriate. Because in that case, that was also a case in which arguments were made that judicial review was more appropriate because the appellant sought mandamus and because it was reviewing a sort of administrative decision with respect to broadcasting. And the court in that case said and chastised the very restrictive approach to constitutional rights or to the jurisdiction. The court said that at the heart of the case was the right to freedom of communication, and therefore that did warrant the court's constitutional intervention. And so, as previously mentioned, Your Honors, we say that at the heart of this case is the right to liberty. The claim for protection of the law cannot properly be understood and appreciated solely on the failure to afford the opportunity to be heard, but rather the failure to afford the opportunity to be heard, and then the consequences that had, the very severe consequences that would have had on the appellant being able to continue to enjoy his status, his status of liberty, regardless of how restrictive it would have been. And so, Your Honors, we say that lastly, we just say that it would have been the duty, or that it is the duty of the court to ensure that administrative decisions conform and comply with fundamental constitutional and human rights values, and that the court exercises a custodian power to guard the integrity of the Constitution and uphold the constitutional supremacy. And restrictions of this kind then really would have warranted the court's anxious scrutiny, considering that we are talking about one of the more sacrosanct rights that we had. And so it would have warranted the court's constitutional intervention and the exercise of its jurisdiction under Section 20 in particular. Your Honors, if the court is with us, then I will move on to simply make some submissions with respect to the substantive claims that we make before the court. Namely that one, we invite this court then to determine that the 55 days pre-revocation detention breached the appellant's right to liberty, that the failure to afford the appellant an opportunity to be heard was a breach of the right to protection of the law, and that the detention conditions also breach the appellant's rights against inhumane and degrading treatment. On the first one, Your Honors, we have already mentioned that no justification has been provided as yet. No reference to any legal principle or any statutory provision that would have authorized his detention prior to the revocation of his parole board. And so we say that that manifestly is a breach of his right to liberty under Section 5. As regards the right to protection of the law, the respondents do not deny that the appellant was not afforded an opportunity to make any sort of representation whatsoever. What they say is that parole is a privilege, and as such, because it's a privilege, then natural justice principles are excluded. They also say that because there was a clear violation of a breach, then in any event, it wouldn't have made any difference if he would have been actually afforded the opportunity to be heard. Here we rely, Your Honors, on jurisprudence and cases coming out of the European Court of Justice, the House of Lords, the US Supreme Court, as well as Gregory August emanating from this court, that have all established, in fact, that the principles of natural justice are not excluded from parole proceedings, and that in fact they do apply. The manner in which they may apply may vary, which I think is what the sole authority or reference that my learned friends have made with respect to the application of natural justice principles to parole proceedings or immigration proceedings. However, what that is, in my view, what that is speaking about, or at least what the cases say, it doesn't mean that natural justice principles are completely excluded. It's that their application might vary depending on the circumstances. And that's what we see in the case of Saint Germain that has also been provided to the court, Your Honors. We would also commend to this court the paragraphs 111 to 120 of the judgment in Gregory August. And that judgment, Your Honors, can be found at page 923 of the record. And here we see that the court makes the point that minimum due process guarantees do in fact apply, and also that what could be considered as a reasonable cause that would warrant a revocation of parole, also there are also particular principles that apply. And one of them being that there must be some consideration about the potential risk to the public. So that we see that the fact that you might frame parole as a privilege is not really dispositive of the matter, because the deprivation of rights as well as privileges are considered to be as of equal importance, because they might be equally impactful on the rights of individuals. As regards the respondent's argument, the de minimis argument, essentially, we say, Your Honors, that on this point, we rely on the House of Lords decision of Ex parte Smith to illustrate the error in such an approach. This is because in that case, Your Honors, the board noted that even if important facts are not in dispute, they may be open to explanation or mitigation, or may lose some of their significance in light of other facts. While the board's task certainly is to assess risk, it may well be greatly assisted in discharging it by exposure to the prisoner or the questioning of those who have dealt with him. The prisoner should have the benefit of a procedure which fairly reflects on the facts of the particular case, the importance of what is at stake for him as for society. So the own parole and the revocation of parole, it is not that the only consideration is whether the parolee has been compliant with the conditions of parole, but instead there are specific principles that must be applied. And one of them is, in fact, the risk that the parolee might present. In addition, the parolee should also be given an opportunity to provide, even if mitigating explanations to the board before parole is revoked, and that is one of the purposes of allowing him to make representations. This was not afforded to the appellant, and in fact, there's nothing in the response from the respondent which showed that at any point in time there was any consideration about the question of the public risk, or even the alternatives that were included in the prison rules that also say that you can revoke, but you can also vary the conditions which might be able to attend to whatever risk there is. So it's not automatic that once there is a breach of a condition, then that the rules or that the principles of parole even envision that an automatic revocation of your parole would be necessary or would obtain. In this case, we say that it was...
Before you go on, Ms. Mendez, do we know what facts or factors would actually taken into account by the parole board in this case?
Your Honor, from the affidavit that was provided, that is part of the record, the only thing that we have is the fact that there was a breach of the condition. That's the only thing that the Mr. Virgilio Murillo, who was the deponent on behalf of the respondents in his affidavit, the only thing that he makes mention is the breach of the conditions. And in fact, what he says is that it is not the practice of the parole board to give a parolee an opportunity to make representations after they have blatantly violated their parole conditions. So throughout here, we don't have any indication that any other consideration would have been taken into account. The appellant obviously would not be in a position to provide that information as to what factors might have been considered other than what is communicated to him by the parole board. And
yes,
you see that...
Mendez, just give us the page of that you're reading from, and let me know as well. Does the parole board issue that directive in writing?
Yes. So let me just give you the page first, Your Honor. That's page 122 of the record. And that is in the second affidavit of Mr. Virgilio Murillo. And so there, the appellant did receive that directive in writing, and he received that in May, preview indulgence. That was on the 28th of May, 2014. So you can find this too, Your Honors, in page 94 of the record. And that is when he was given the notification in writing. So he was detained on the 4th, and it was until the 24th that he was given that notification in writing.
You were detained on the 4th of which month?
The 4th of April.
And the notification was?
On the 28th of May.
Thank you.
Just something I wish to clarify, Ms. Mendez. Do I understand the appellant's complaint to be that for the 55 days between the 4th of April and the 28th of May, there was a breach of his right to protection of the law and his right to liberty, and that from the 28th of May onwards, there had not been any natural justice afforded him? Is that the case? Was he afforded a natural justice when the parole board made its decision ex post facto revoking his parole?
No, Your Honor. No, Mr. President, he was never afforded an opportunity.
So down to this day, his reincarceration has not been validated by a process which had allowed him natural justice?
No, Your Honor. No, he still has not been afforded any opportunity. What happened, if I could, just because we're here, if I could just very quickly summarize, on the 4th of April, because he was already working at the prison He was there working as an emergency technician, I believe. And because he was already working there, this is why he was just detained and not allowed to leave from the 4th of April. And he was then instructed to just remain at the prison. He remained there at Tango 10 all the way up to May 28th. At that time, he was just given the notification that it had been revoked because he had tested positive for cannabis. And so even when he was detained on the first detention in April, well, he was not given an opportunity. He was just told to stay here because they are going to take a urine test to see if he tests positive for any drugs, and then he would be in breach. Also, if we go to just for the court to have at page 104, that's the written notice that the appellant was given, informing him that his parole had been revoked. And if we look very quickly at this notification, again, the only thing that is referenced is the breach of the condition. And so it is my understanding that at least everything that has been related to us by the parole and by the parole board and by the respondent, that would have been the only consideration that was taken into account in revoking his parole.
So the parole board, since then, has the parole board ever considered his situation?
Your Honors, when here we say, here we do have in the affidavit, yes.
Go ahead.
I would say that they have not considered it. And what I want to bring to the court's attention as well is that prior to instituting the claim, one of the first things that we did was to write the parole board for them to review this decision and give him now an opportunity to actually be heard, or at least to reapply for parole, considering what has happened, for them to be able to put things in order as opposed to us rushing to court. You will see that in the affidavit, we have gone through quite some detail to sort of like elucidate on the troubles that the appellant would have had in trying to retain counsel and trying to actually get assistance. So one of the first things that we did in order to also not have him go through lengthy proceedings that might just extend his time, that might just end up extending his time in prison, we wrote to the parole board asking them to rehear this matter, or to now consider the decision, but giving him an opportunity to be heard. To this day, we didn't.
In the record?
Yes, Your Honors. Yes, Your Honor.
What's the date of the letter then, Ms. Mendez, of the page? Thank you.
Certainly. Okay. That would have been that is at page 95 of the record. Paragraph 22 of the affidavit of Hillaire Sears.
And what was the response to that letter?
We've gotten no response. There was no response to date. And the letter is at page 113, Your Honors.
What was the date on that letter?
The 4th of September, 2017.
Thank you.
And so our information is that no, the parole board has not taken on any proactive steps to try to remedy the flaw. and the appellant has never been given an opportunity to make any representations with respect to the revocation. Lastly, if I could just very quickly highlight the key points with respect to the detention conditions, Your Honors. Essentially, we say that from the evidence, we do see that there were some key conditions in his detention that really do rise to the level of inhumane and degrading treatment, because they really go beyond what would be required. And namely, we highlight the fact that there was a lack of privacy that the appellant was subjected to with respect to the use of the bathroom, Your Honors. That was something that was by and large accepted by the other side. And we do say that this particular condition is one that I think is rather undignified and does rise to the level of suffering far more than the conditions and what you would expect to suffer once you're in detention. There, in addition to this, buckets would have been provided, and there's not a denial that when he was in administrative segregation, they would not be allowed to leave the building, so that they would have to use the bathroom and use these buckets, and they would also be eating and just be there the entire day until they are emptied out at 7 a.m. according to Mr. Virgilio as well. You also find that there were really restrictive conditions placed on him with respect to being allowed visitors, family and friends that would come to visit him. At least for 3 months, he was not allowed any visitors whatsoever. And we do say that these are conditions that rise to the level of inhumane and degrading treatment, such that his rights under Article 7, under Section 7 of the Constitution would also have been breached. These really are our submissions, Your Honors. It's on this basis.
What's the relief that you are seeking?
We are seeking damages, compensatory and vindicatory, as well as an order that the appellant be released, Your Honors. We see that that is at this point really the only way that the appellant, that this particular breach would be given an effective remedy.
Ms. Mendez, what did the Court of Appeal make of your substantive claim? Was there a proper determination of your substantive claim before the Court of Appeal?
No, the Court of Appeal, no, Your Honors. The Supreme Court did make did find on the substance of the claim, and essentially Justice Arana found that she agreed with the position that parole is a privilege and that there was a breach of the condition, and therefore there was no right to be afforded a hearing. But the Court of Appeal did not yet make any findings on the substance.
And what would you say, Ms. Mendez, if the court, and I say if, the court were with you, what would you say of any suggestion that the matter be sent back to the Court of Appeal for hearing on the substantive claims?
You see, Your Honors, I mean, obviously we are in the court's hands, but the concern here is the time that has lapsed already. Our position would be that we would consider this court to be well placed to find on the substantive claims, simply because as well, I think as we have laid out, the jurisprudence with respect to whether you have a right to natural justice, especially Gregory August that emanates from this very court, is quite clear. There's no controversy with respect to the facts, really. What my learned friend's response to our claims is quite blunt, and it's quite clear. Their position is that there's no, that their natural justice principles do not apply. So our position would be that we do think that this court is well placed to make a ruling on the substantive claims, and that at this point, just considering the delay that has already happened, we would ask the court to take that into account in considering whether to take it back to the Court of Appeal.
Just to ask you this, Ms. Mendez, and I could be entirely wrong, but was it the case that the counsel for the appellant had this specifically invited the Court of Appeal not to adjudicate on the substantive issues if the Court of Appeal found against the client on the procedural matters?
Yes, yes, Your Honors. Okay, so the matter before the Court of Appeal was heard in writing, and I was involved in that, and I think that there was some. To be fair and frank, I think that there was a simple, perhaps a misinterpretation, where the approach was that we were going to address the issues of we were going to address the question about whether it was the wrong procedure in the beginning, just considering that these are, you can look at it as technical issues, so or preliminary issues rather, that had to do whether it was a wrong procedure and whether there was delay. This was also another issue that the Supreme Court looked at. And so in our written submissions, we said we will start off by addressing the court in these 2 points, but we still went on to make full submissions on the substantive claim. So it's not that it was bifurcated, and I think it was not that we invited the court of, okay, well, we don't want you to rule on the other matters if it is that you find against us. It was just explaining why our ground 7 and 8, why we were addressing our ground 7 and 8, and it was not in chronological order. But it was heard, it was dealt with on paper.
Right. So the Court of Appeal may have mistaken your intentions in terms of you're wanting them to adjudicate on the substantive issues. And that's what I got your answer, maybe.
That is completely possible.
Okay. The inhumane conditions you mentioned, could you just say whether those were unique to the appellant? As I know this question is not dispositive of the issue, of course, but I'm just curious as to whether your client was singled out for these kinds of conditions, or they were commonplace amongst the inmates.
No, our understanding is that it was commonplace. So it was not targeted towards the appellant, and that's what we have in our affidavits, Your Honors.
Thanks. Two small questions just to finish up. In terms of the procedure to be followed to ensure natural justice, I assume that you are not necessarily insisting on an oral hearing, but a process whereby your client can put his case. Is that so?
Precisely, Your Honors. The claim that the case that we put before the courts was one where we used the jurisprudence that says that you're even entitled to an oral hearing, but simply to make the point that a fortiori then at least some opportunity to even provide written representations is what we were seeking and did not obtain in this case. So at least we don't see this case as being one for the court to determine whether an oral hearing precisely is needed in order to fulfill the minimum guarantees of due process. And
that stands consistently with the conditions under which your client was released on parole. because I gather he was released on parole on the condition that he would not breach any of the conditions specified, and that he agreed that in the event he breached any of those conditions, he would be, not much of the word liable was used, but he would be exposed to the possibility of being returned forthwith to the prison.
Yeah, the parole may be revoked.
Or may be revoked.
Yeah.
Okay. Now, in relation, you spoke about the 55 days that the Parole Board took to hear this matter, it seems. Without commenting on the reasonableness or otherwise of that length of delay, I'm just wondering what sort of time frame in your view would have been acceptable? Obviously, from your point of view, 55 days is much too long. I understand that, but the day that the client is detained, I imagine it would not be feasible to have the board meet on that particular day. So what's a reasonable time within which you think the parole board could have considered the case, and obviously from your point of view, and I think generally speaking, give natural justice to your client? Would 1 week, 2 weeks, 3 weeks have been, what sort of time frame is reasonable?
But you see, Your Honors, I'm guided by the statute, and the statute specifically only provides for the detention of the parolee once there is something in writing directing that he be recalled. Otherwise, you can, breaching one of the conditions is also an offense, right? But if you will charge him, then obviously all of the protections that are associated with a charge, such as bringing him before a magistrate court and all of these things, would also have applied. So there's nothing in the
sorry,
rule.
I not to interrupt, but you are then speaking about the relationship between section 272 and 274. Are you?
Yes.
Right, because 274 contemplates, I'm sure you'll agree, paragraph 2, that if a prison officer has reasonable grounds for believing that the parolee has breached the condition of his parole, the prison officer may arrest the parolee without warrant. I think it also says that he should have sufficient evidence, yes. But the point is that the prison officer can arrest the parolee without warrant, right? Are you contending that your client did not breach the conditions of his parole?
No. No,
so you
Your
admitted
Honor,
that he breached the conditions of his parole? Yes? I'm sorry, please.
No. Were you just making reference to Rule 272, right? 272.
272, is that the one which allows the parole board to recall the parolee?
Yes.
And that's a context, I imagine, in which due process, obviously, ought to be given, not necessarily an oral hearing, but certainly a chance to put the case, right? So
yes,
that's
and that specifically includes a requirement that it be in writing.
Yes, so, absolutely, yes. But no, I'm also thinking of 274, paragraph 2, which allows, as I recall, a prison officer to arrest a parolee for breach of the conditions of his parole.
Okay. Could I crave your indulgence to just quickly find that provision?
Yes, of course.
$274?
Yes, Ms. Mendez. Paragraph 2, particularly.
Okay. It goes back it goes back to what I had mentioned, Your Honors, is that this particular provision speaks to when you are treating the breach as an offense. So that I don't think that 274.2 is a standalone. That is simply giving the authority to a parole or prison or police officer for them to be able to detain him, but again, read together with the objective that he would charge him for an offense, and not necessarily part of 272. I think that because it's contained specifically in the provision that deals with offense for breaching conditions, then again you assume that all the protections attendant to how you treat charges of offense or offenses, then those protections would apply. But that's not what happened in this case.
So you're saying then, and you could very well be right, I'm just asking you because I need clarification. You're saying then that if the prison officer has reasonable grounds to believe that the parolee has breached the terms, conditions of his parole, the prison officer, and has sufficient evidence, the prison officer can in fact arrest, detain the parolee. Now, if that happens, is it required that the parolee be presented to the magistrate and a charge be preferred, or is it also feasible for the parole board at that stage to come in, which is I was asking you, the 55 days is, to then come in and make a decision? Because if the latter, then it seems to me that, the parolee would be getting the benefit of the procedure. He would not be exposed, he or she would not be exposed to the additional charge, which carries both a financial penalty and of course the possibility of imprisonment, and would simply be dealing with the revocation of the parole. But you are bifurcating those two procedures and you're saying that they are completely different procedures, are you?
Yes, Your Honors. I am saying that they're different procedures because if they are not, then we end up in where we are now, in my humble opinion. I think that when we're looking at 272, it really is simply providing that, one, the breach of condition can be an offense, and it is a summary, it's an offense liable on summary conviction. And then that particular subsection that, that Your Honor brought to my attention is simply giving the parole, prison, or police officer the power to make an arrest without a warrant in these particular circumstances where with the aim of charging him for the offense, right? Because if we then look at subsection 3, it goes on to speak about the conviction and the sentencing. So it's really something that is quite unique, and it must be because it assumes that all of the protections that are attendant to something like that, to a criminal charge, would already be embedded within them. Whereas where you can then detain, it would only be when a decision now has been made to revoke. And remember that a parolee is unlicensed. So there's no real reason to detain him in this manner, and there's no necessity to detain him in this particular manner for this amount of time prior to you revoking his parole. He's already unlicensed. You are already supposed to have some supervision of him unless there's any indication of absconding. But I think that, but I don't think that that is what is embedded within this regime. The fact that it very clearly says that it must be in writing, and it's until then that it empowers them to detain. I think we're talking about two different avenues that are available.
I follow you very closely, and as I said, you could very well be right. I think one of my difficulties is that the parolee had in fact agreed as one of the terms of his release that if he breached any of the conditions, which is admitted, then he could be returned to prison. I need to read exactly what the language was, but it sounded quite peremptory to me in terms of what the consequence would be for a breach. But I hear you loud and clearly, and thank you for your very clear submissions. Those are my questions.
If I may make one observation as to the last point, Your Honors. I think that's quite part and parcel of parole in general, that the parolee is released under certain conditions, and I think it's also quite common for that license to then say upon a breach you may be susceptible to being recalled. But I don't think that particular license can exist separate from the statutory provisions, the principles of natural justice, proportionality. I think all of those protections, due process protections, would be read into the license, and that's because of the supremacy of the Constitution, as well as the impact that would have on the right to liberty, which I think the authorities also quite clearly established that, yes, with respect to revocations of parole, we are talking about a change in the state of liberty of the parolee.
No, I follow you. I was just trying to say that I was just trying to see there was a line between that kind of concession by the parolee, kind of agreement by the parolee, and 274-2. But I gather you think that there's not, and I understand why you think there's not. Thank you very much.
Yeah, I was.
No, please.
Yeah, no, just something that segues from what Justice Anderson raised, and that is, I think the discussion becomes interesting if we think that there was a situation where the parolee was not working in the prison on that day, but had been arrested somewhere else, where, and for me, I would like to look at that further. Where would be the authority to take him to the prison and put him there without going through 274-1 as suggested by you? Because I am mindful of what 272 says, but that is for another discussion. Thank you, Ms. Mendes.
Thank you, Your Honors.
Yes, Ms. Mendes, of course, it says that if you violate one of the conditions, you may be brought back to prison to serve the rest of your sentence. But my impression is it's not always, or not usually, all or nothing. So it would seem normally in parole practice that there would be variations, that you could say, well, yes, you violated, so you go behind the bars for a while, but then we'll do something else, or we look how you behave, and you may come back after a year or after 6 months or whatever. Can you tell us a little bit about, is there anything to tell about the practice of the parole board in Belize? Is it always all or nothing, or are there other things that the parole board does or could do?
Yes, Your Honors. On that point, yes, there are different options that are, I think, in theory available. And I just want to make the point that, for instance, in the case of Smith, one of the things that were considered was that similarly, the breach of the condition in that case was one of drug use. And so one of the things that were considered to put in a condition that the parolee attends rehab, for instance. In this case, in our affidavit, and if I may take the court to that, in our affidavit, the appellant, the claimant then, did speak to a practice at the prison as he knew it. Save your indulgence, I will.
Because you were mentioning the principle of proportionality.
Yes. And if we look at page 94, he he speaks about his knowledge about parolees who have tested positive for drugs being given an opportunity to undertake a rehabilitation program at the prison, which was for 90 days. And then they would be released after they would have successfully done that program. He speaks about it being commonplace, and he refers to three other parolees that were subjected to this. I do believe, however, that the respondents in their answer did not really accept the veracity of those statements. But it was something that was placed before the court. And in fact, what I can say, however, is that there is a rehabilitative program at the prison, obviously.
Thank you.
Unless there are any other questions, Your Honors, that really are my submissions. Grateful.
Yes, thank you very much.
Much obliged.
Ms. Tucker, we take a 4-minute break. By my time, it's 12:06, and we will hear you at 12:10.
Much obliged, Your Honor. Much obliged, Your Honor. If it pleases you, Your Honors, the respondent relies entirely on its written submissions that have been filed in relation to these proceedings. However, the respondents will highlight some of the important issues that the court ought to consider in its determination, and the respondents intend to respond and to distinguish some of the cases that my learned friend has sought to rely on in these proceedings. Firstly, we'd like to draw the court's attention to exactly what has transpired in relation to these proceedings. We're talking about an alleged detention that took place from the period April 4th to May 28th. As a result of that detention, because it was found that the appellant had in fact breached one of the conditions of his parole, and to be clear as to what were the consequences of his breach, if I may take Your Honors to the conditions for parole, and this can be found at page 101 of the record. And if I may take you over to the second page of the conditions and restrictions, it is there in bigger letters than the conditions themselves. It says, if you violate any of the conditions of your parole, you are subject to arrest, revocation of your parole, and return to the Hatfield prison. So here it is very clear to the appellant what would have been the consequence had he breached any of the conditions of his parole. And we say that this is in line with the prison rules.
Okay.
Additionally, in relation to the conditions here, there is a certification provided in which the appellant himself agreed. It says, I hereby certify that I have this day received a copy of the conditions of parole. I have read or had read to me the conditions, and I fully understand and agree to comply with them. Essentially, he has agreed to comply strictly with these conditions, and he has agreed to the consequence if he breaches any of these conditions.
But counsel?
Yes, Your Honor.
Sorry, yes, this is pursuant to the question which was raised with other counsel by Justice Anderson. Isn't the Prison Rule 274, doesn't it deal with expressly with what happens for the breach of a condition, quite apart from any agreement on the part of the parolee? Is it?
Yes, please, Your Honor.
Isn't the agreement to be read subject to the paragraph 274, 1, 2, and 3?
Yes, please, Your Honor. We do not deny that this has to be read in light. However, our position is that this is compliant with what the prison rules allows for in a case where there has been a breach of conditions for parole. Because if I may take Your Lordship to section or regulations 274 subsection 3, it says that the conviction and sentencing of any parole under this rule shall not limit the power of recall conferred by this part. So there is power still within or
Yes.
given to the parole board to make that determination to recall.
But doesn't section 274 envisage a certain procedure which involves the summary jurisdiction of the court, and that certain things have to be done even though there's a breach of condition, or where there's a breach of condition? And this is separate and apart from regulation 272, which deals with the power of the board to revoke the parole. Am I reading these regulations incorrectly?
No, please, Your Honor. That is the interpretation that we share in relation to these provisions that Your Lordship has identified. However, we say in the circumstances that considering that the appellant would have already been detained based on the reasonable suspicion of the officer, that in the circumstances, it may not have been prudent or in an effort to save time and resources to have the matter addressed summarily before the magistrate's court when there is the provisions under the prison rules which allows the parole board to make a determination whether to recall the appellant in these circumstances to continue the service of his prison sentence.
I'm still continuing to think that Regulation 272 contemplates a different jurisdiction, the exercise of a different jurisdiction from Regulation 274. I'm still continuing to think that, but you may disagree with my thoughts, and you may continue.
Ms. Tucker, which rule, under which rule was the appellant reincarcerated?
Your Honor, if it pleases you, based on the evidence before the court, it cannot be explicitly stated based on what provision of the prison rules the appellant would have been detained. However, on a review of the prison rules, section or regulation 274 subsection 2 seems appropriate in the circumstances to have allowed lawfully for there to have been the detention of the appellant based on the sufficient or reasonable suspicion that the officers had in relation to the actions of the appellant. And if I may take your lordships and your lady to the affidavit that has been filed by the respective.
No. We don't want to go to the affidavit just yet. I want to get clear in my mind the legislative justification of the prison authorities for the action that they took. And you say that he was reincarcerated pursuant to Rule 2742?
Yes, please.
But doesn't Rule 2742 only provide for his arrest without a warrant? Doesn't it contemplate that 274(1) would then kick in?
Yes, please, Your Honor. I cannot deny the effect of what the regulation provides.
So 274(1) contemplates that he is going to be taken before a magistrate who can then find him guilty of an offense or revoke his parole or both. Isn't that correct? Or even fine him?
Yes, please, Your Honor. That is essentially what the provision contemplates.
But that wasn't done here.
If that was not explicitly done in the circumstances of this case.
So then, what was done was without legislative authority.
With respect, Your Honor, I would disagree to the extent that there is.
Tell me, what is the authority?
Well, the authority would have been Regulation 274(2). That there is.
You're wrong in a circle, Ms. Tucker, because you said to me that 274(2) requires that he be arrested, that he be brought before a magistrate, who then imposes the penalty. Which magistrate imposed the penalty of reincarceration here?
There is no imposition of any penalty from a magistrate in relation to reincarceration.
However,
so 274 was not followed.
in its entirety, Your Honor.
In other words, the prison authorities can deal with a man who is on parole as they please. They could just say, well, look, we suspect you of having committed an offense and we put you in the slammer. That's what has happened here.
Your Honors, I can see how it would appear that would have transpired in this case. However, that is not how it should operate.
It's not what appears. We don't want to look at what appears. We want to see what was done. And what was done, according to the affidavits, was that the prison authorities had a parolee who happened to be working in the prison at the time when they suspected that he had engaged in a violation of his parole. And they simply took him and put him in the cell. Ex post facto, they got justification for putting him in the cell by his urine analysis. But up to this date, no magistrate has actually become involved in the 274 procedure, so that a court looking at what transpired cannot say that he was dealt with according to 274. So let's look then at 272 to see whether he was dealt with in relation to 272. And in relation to 272, the board never gave any directions in writing until 55 days after he had been in custody. Is that correct?
Yes, that's correct, Your Honor.
So for those 55 days, let us just use the euphemism that there's a question mark about the lawfulness of his incarceration, because it wasn't done pursuant to 274, nor was it done in pursuance to 272. But even in relation to 272, if a board has reasonable cause to revoke someone's parole and they're required to allow the person some form of natural justice, what's the practice?
Your Honors, I cannot hide or shy away from the fundamental principles of natural justice where it relates to, or where decisions will affect the rights, even in these circumstances where the rights would be limited. So I cannot shy away from that position that there ought to have been in this case the opportunity for the appellant to at least explain why it is that the matter transpired the way that it did.
Okay, proceed.
However, just going in light of that submission, considering the nature of the claim, when you look at the substance of the claims and what it is that the appellant is seeking, that is to be released forthwith and to have the decision of the parole board quashed, then we say that it was properly to have been brought by way of judicial review proceedings. And even the cases that my learned friend has provided to support her contention, or the appellant's contention, that the claim is properly a constitutional claim, when you look at those cases, they all started by way of judicial review proceedings in a matter of reviewing whether the parole board had acted in accordance with the principles of natural justice in making its decision. For example, in the case of R and Hall Prison Board and visitors, this was a case in which they were seeking judicial review proceedings. They applied for leave to move for orders of certiorari to quash the awards made by the board. And this was in relation to the exercise of the functions of that board. Also, in the case of observer
publications. While in the end it turned out to be a constitutional claim, there was also a judicial review claim that was made for mandamus, that the commission issued the telecommunications license to the company. However, the court found that that matter or that claim for the judicial review proceedings was substantially subsumed in the constitutional proceedings. And looking at the facts of that case, what the court said is that there was no valid objection provided by the telecommunications board in denying a license to the entity. And it is for that reason that they said that, considering that one of the issues in that case, which is the freedom of expression, and this is of course enshrined in the Constitution, that it was for that reason that the case properly could have been dealt with by way of constitutional motion.
But if a person is in custody for 55 days without, in their view, lawful justification, wouldn't you consider that to be an issue which could prompt a constitutional action?
If it pleases you, Your Honor, we do not deny that that may prompt. However, what the case law has established is that if there is an alternative private law remedy that can be utilized in order to achieve what it is that the complainant is seeking to achieve, then that claim or that remedy ought to be pursued. And in this case, if it is that the appellant was alleging that his detention was unlawful for that period, that 55-day period, then he could have properly challenged that by way of a false imprisonment claim.
Could an action for false imprisonment yield relief that said he should be not be made to serve the rest of his sentence?
No, Your Honor, and that is where I was going to get at in terms of the reliefs that are being sought. Of course, and one of them is to be released forthwith. Now it is unclear as to whether it would be to be released as in to be free, having essentially served his sentence, or is it to be free but on parole? So that is one of the questions.
The point is that the question I asked had to do with the appropriateness of remedies and the possibility for arguing remedies. Is very different in a false imprisonment case or a case of trespass to the person and a constitutional case. In a constitutional case, the remedies are at large, whereas in a case of trespass to the person, the remedies are very definitive and not so extensive.
No, yes, Your Honor, I do agree with the position that Your Lordship have expressed, and considering that the reliefs being sought by way or to be granted by way of a private law claim for false imprisonment is very limited, and it may only be limited to the award of damages if it is found that the person would have been unlawfully detained. However, in looking at the circumstances of this case and based on what it is that the appellant was seeking, he was essentially seeking to be released from custody. He wants to be free. And so without limiting the decision to a claim for constitutional relief, it could have properly been brought for a claim seeking administrative orders under Part 56, and this could have properly included a claim for constitutional relief as well as a claim for judicial review, of course going through the procedure in order to get the court's permission to pursue judicial review proceedings.
Now this is all very nice stuff for lawyers, but how do you expect the average prisoner who finds himself in a cell like this gentleman to know all about this. For example, if the decision of the parole board would have said, okay, this is our decision. If you don't agree, you have so much time to do this or that. At least that would make it clear. But even the lawyers apparently are not clear whether judicial review was the appropriate way to go, and under the circumstances as it stood, as the law stood at that point in time. So, you know, that makes the safeguards that you should have around liberty makes them quite weak, and therefore the question is then for whether that, from a constitutional lens, whether that is if that law is of sufficient quality to withstand the scrutiny of a court looking at the rule of law.
Your Honors, and that is where I was going with my next point. While it is that my learned friend is contemplating that there were breaches of the appellant's constitutional rights, there has been no challenge to the prison rules to say that the procedure was not followed, or to say that the prison rules were unconstitutional and not in compliance with what Section 5 and Section 6 prescribes.
Well, they might be constitutional if read in a certain way. It all depends.
And that is so, but as I said, with respect, that there has been no challenge, no constitutional challenge brought in relation to the prison rule to say that they are in fact unconstitutional. What has been challenged is, one, the detention, and two, that the appellant was not given the opportunity to be heard, not to say that the procedure under the rules were not followed.
Yes.
So that would address that submission. I wanted to discuss the issue of the reliefs that are being sought by my learned friend. While it is that there may...
Before you go there, could I ask you that we saw about this this test that was done? Is there any information? I couldn't find it in the file when that test was done, when the results were known, because on the day that Mr. Sears was arrested, of course, there was no result yet, I suppose. I'm not sure.
No, please, Your Honor. There is no evidence before the court as to when the urinal test was conducted and when the results of the test were completed and provided to the parole board. There is only the issue of the initial detention, which would have been in April, and then the decision of the parole board in May. So, yeah, assuming the results would have been within that time.
And so, I don't know what the practice is in Belize, how long it takes to get the result of such a test. It might take, well, it could be done in a day, but it might take weeks too, depending on the bureaucracy. Of course, if it would have taken weeks, then even if the road of 274 would have been followed, you would not have a result at the magistrate, because the magistrates would have said, where's the evidence? That evidence came when the positive test result came in, but we don't know, therefore we don't know when it came in, correct?
No, we don't, Your Honor. Unfortunately, we don't.
Okay.
Mrs. Tucker, the Parole Act at Section 9 reflects, I believe, what is, well, this would be the principal act, reflects what's in the prison rules 272. 9.1 says the board may, for any reasonable cause at any time, direct in writing that the parolee be recalled. And 2, on giving up the direction under subsection 1, the parole order is to be treated as revoked, etc. The parolee may be arrested without a warrant and shall be returned to detention to continue to serve his sentence. So we see the statutory authority for that. As to 274, 1 and 2, will we find the statutory authority for that in the Summary Offences Act or some other place?
Madam Justice, I think that it would be considered that that would be provided for in the summary offenses act.
Are you aware where we might find it, or is that something that we can be told at a later stage, as Mrs. Mendez will be sending some further information that could be included, if it is there?
Madam Justice, I can provide that to you after the proceedings, once I'm given the opportunity to look.
Yes, and I'm looking as well as Section 8 of the Parole Act, because I know you were going on to speak about reliefs. And that also says that when the eligible offender is released from detention, he shall be on parole from the time of his release until the expiry of his sentence of imprisonment, and the term of the sentence shall continue to run while he's on parole. So is it that for the 2 years that Mr. Sears was on parole, his sentence continued to run? So is that how the calculation of 2027 as his release date has been made?
Yes, please, Your Honor. That is the understanding that I have gotten in relation to these proceedings, that essentially at the expiration of the license in December 2027, he would have served his entire sentence.
And served even the 2 years when he was on parole, is that right?
Yes, it does contemplate that period.
Okay. And where do we then factor in the 55 days? But I suppose you'll come to that. Thank you.
And of course, the question about the remission, is there a possibility of remission?
If I may answer Justice Witt's question first, there is a 2017 Parole Act. I don't know if your ladyship was reading from this act, but I did do a quick search and I found the 2017 Parole Act, and it does speak to the possibility of remission.
What section is that, Ms. Because I have the 2017 up.
Okay. So then if I may take your lady to paragraph, or I do apologize, section 4, it says the function of the board include making decisions regarding B, the remission, suspension, or variation of any condition of any parolee, or imposition on any such parolee of any additional conditions of parole.
I thought they were speaking here of the remission of any condition. It's a little confusing, but doesn't appear to be the remission of the term of sentence. But you could probably look at it further.
Well, just having a quick review of it, to me, it would suggest that it would be the remission of the prison sentence.
But it doesn't say so.
It doesn't say so. No, it doesn't say so.
So that should be information that we also would want to have. Clearly, it's very clear what the focus is on what the issues are, but nevertheless, we live in the real world, and so we have to know what is actually doable, what is actually happening, and what can we expect if we take a decision this way or the other way.
Much obliged, Your Honor. I will endeavor to get that information to the court, because looking further in the regulation, in the legislation, sorry, at section 10, there is a paragraph 4 which says a parolee or his parole officer may at any time apply to the board for the remission, suspension, or variation of any general or special condition of parole. So this would suggest or seem to be in line with that expressed by Madam Justice, that it is in relation to the conditions of parole and not to parole itself. So I will definitely endeavor to get further clarity as to the application of remission in circumstances such as this.
Yes.
Even if Mrs. Tucker, you were able to use section 2, or is it rule 274.2? And I know that is hotly disputed, of course. Wouldn't you concede that 55 days is just too long to have this gentleman there not knowing his fate, not having any information about his fate? Those 55 days, wouldn't those prima facie amount to some kind of breach of his right to liberty?
With respect, Your Honor, I could see where Your Honor is going with that argument. And based on what the Constitution provides, I can contemplate that it may appear to breach the appellant's constitutional right not to have been provided, at least with information as to why it is that he was being detained in the initial stages. However, after undergoing that urine analysis or urine test, he could have derived the reason for his detention.
Yes, but as you responded to Justice Witt, we seem not to know when the test results came back. So it could have been on the 55th day that they came back. So I'm just wondering what would have happened in the interim. The other thing that bothers me is what Ms. Mendez, brought to our attention again. It had slipped me that the appellant had written to the board on the 4th of September 2017, she says, basically seeking a rehearing or revisiting of his case, and that apparently they have not heard back from the parole board. Now that is basically almost 5 years. It seems to me that there is the possibility that even though a parolee has been recalled, he or she can be granted parole again. I mean, that is implicit in Rule 272, which says that the parolee shall serve the remainder of the sentence unless he is again released on parole by the board. So obviously the board has jurisdiction to release the parolee again. The parolee basically has the power to apply for parole after serving a half of the sentence, which this gentleman has done, and can apply every 6 months actually to the parole board to say, it's time for you to let me out on parole. So it's a little bit unnerving that almost 5 years have gone and the parole board has not responded. Can you shed any light on this?
Unfortunately, Your Honor, I don't have any information as to what would have transpired in the preparation to defend this claim. I was not counsel in the court below, so I do not have any information as to why or why not there was no response to the letter by the appellant in the circumstances.
Yeah, but generally speaking, you would have expected that the board would have responded. Of course, you don't have to respond in the positive to say it's time for you to go back out on parole, but surely there should have been a procedure to consider the request and then a response. That's a little bit troubling.
Yeah, Judge, Mrs. Tucker, can I say that Section 9 of the Parole Act, in fact, says that the board shall determine, having regard to the nature and circumstances of the recall, whether the particular offender shall again become eligible for parole at a later time. So that is something that the board should have a determination on, not just, and more so if counsel attorneys right. But yeah, thank you.
Madam Justice, I do agree with you. I think we have to consider the provisions of this act in light of the circumstances at that time. I believe, well, of course, the decision by the parole board was made in 2014. This act would have only come into effect in 2017. So to say that that would have been a consideration by the board at that time, it is not clear. And so now, if it is, that a person were to be recalled at present, or at least after the coming into force of this particular legislation, then of course that ought to have been a consideration by the board in determining whether in fact the person would have been eligible for parole again.
Yes, I understand what you're saying, because this act came to effect, I believe, March of 2017. Attorneys wrote in September of that year. Thank you.
Much obliged.
Are there any criteria, as far as you know, that the parole board could apply in deciding whether it's time to look at a new parole or not? The whole thing is kind of vague. There is a parole board somewhere, and at some point a decision comes off. It seems a very unclear process what is happening here. So if I would be a prisoner, I would want to know, okay, what are the criteria so that if I need to behave, I behave properly, and then I will be able to get another bite at this cherry. At least you have to know what is expected of you as a prisoner to be able to get the court at least think about another parole. Is there anything known about that? Is there legislation? Is there any document which they would use? Any standards, criteria?
Your Honor, I am not aware of any criteria provided in any policy document or legislation which would guide the parole board in its reconsideration to grant parole again. However, there is provision in Regulation 266 which set out the conditions that the board should contemplate in deciding whether in fact to grant parole. And this would be at Regulation 266.2, and a part of the considerations include the safety of the public or any person or class of persons who may be affected by the release of the offender, the welfare of the offender, any representations made by the superintendent of prisons or the commissioner of police, the probable circumstances of the offender if released, especially the likelihood of his peaceful reintegration into society, and the reasonable probability that the offender will live and remain at liberty without violating laws.
Yes, but we don't know what kind of information the parole board gets before it, huh?
No, I am not aware of what information the parole board gets. However, just looking at the consideration here, it says any other information or representation which the board may think fit. So it seems as though it's any information that the board considers to be relevant to the case at hand that it will consider in making its determination.
Yes, the more reason it seems to hear what the prisoner has to say. But anyway, you were going to argue about the
release.
The reliefs, yes.
Yes, I wanted to address particularly the relief of being released forthwith. As I was submitting, as I was saying, it is unclear as to the circumstances of the release of the appellant. Is it to be released having considered to have served his prison sentence, or is it a matter to be released on parole? And if it is either of those circumstances, the respondents respectfully submit that the court does not have the jurisdiction to make that determination in the circumstances, particularly since it is the parole board that is granted those powers and functions under the Prison Act as well as the prison rules in order to make a determination whether a person serving a sentence is eligible for release on parole. And I would go even further to say that in terms of the prison sentence itself, the appellant not having served the entirety of his prison sentence, which is actually due until December 2027, then there has been no appeal by the appellant in relation to his prison sentence. And so again, respectfully, we would submit that the court does not have the jurisdiction to make such an order.
You see, this is why it was a little strange that the Court of Appeal peremptorily ruled that he was not entitled to bring a constitutional motion, because if the constitutional motion was considered to be well brought, then the relief on that motion constitutionally is at large. So that what you have just submitted is quite correct if you are within the realm of common law. But if you're within the realm of the Constitution, then a court hearing a breach, an allegation of a breach of a constitution, is entitled to give such relief as is considered appropriate. And there aren't any strictures on what the court may or may not consider appropriate. And maybe this is one of the reasons why the appellant brought his claim as a constitutional claim. So the state can't have its cake and eat it. It can't say on the one hand, the court doesn't have any basis to grant a particular relief. But on the other hand, when he brings a constitutional claim that would allow for the relief that he's seeking, the state then says, well, no, you shouldn't bring your claim under that head. You should bring it under another head. Which other head would not allow him, as you have just explained, to seek the kind of relief that he actually wants.
I understand where Your Honor is coming from with that proposition. And that is the reason why it is the respondent's position that the claim ought properly to have been brought by way of judicial review as well as private law. And that would have been for the false imprisonment. Because considering the circumstances under which the appellant was released, he was released on parole. And parole is not a matter of saying that the person has served his sentence and he is free. Parole is a mechanism that allows the appellant in these circumstances to continue the service of his prison sentence, or his sentence, I should say, without having to be confined to the prison. But of course, subject to certain conditions and restrictions which the Parole Board sets out.
It would seem to me that if the court would order his release, that would not affect either the sentence or the parole situation. It would only affect his freedom. But it would seem to me that, and we can ask Ms. Mendes, but I don't think that they intend to that any measure that we would take would affect, if it could, either the sentence or the parole matter. It would still be, in that case, as I see it now, under parole, so that would, and of course, if the court would take that decision, then it would not mean that the court would give Mr. Sears a parole. It would simply mean that the court will sanction some violation that it has seen here. That, I think, would be all, but I'm just thinking aloud. But of course, we are not there at all. But if it would come to that point, it would seem to me that sentence and parole would be unaffected.
If that were the case, then, Your Honor, we would have no issue with that approach by the court. However, just thinking based on what Your Honor has just stated, if it is that the appellant would be released on parole, what considerations would this court have before it in order to make that decision? As it is based on the documents before this court, there is nothing for this court to even consider to say that that the appellant satisfies any of these criteria that the parole board should consider in granting parole or not. One, this court doesn't know the safety of the public. This court doesn't know the welfare of the appellant. This court does not know for sure if there is a reasonable probability that the offender will live and remain at liberty without violating the laws. As it is based on the evidence before this court, there was an admission by the appellant himself in correspondence that he had drafted to the DPP, and I believe the Chief Justice, if I'm not mistaken, in which there he admits that he engages in smoking marijuana, if not on a regular basis, but of course in breach of the conditions of his parole. So there are all these questions that the court does not have the answers to in order to make that determination if it is that the court should agree that the appellant should be released on parole.
As I said, if the court would go that way, then any order to release is not a decision to allow parole. That is a different story. It would simply be a sanction on a violation that we might or might not find. So it would not affect it. But anyway, there are, of course, issues that you mentioned that are also important to look at if we are practical. Anyway, I think you made your point quite clear.
Much obliged. Unless there are any further questions that I could assist the court, those would be the points that I would like the court to take note of in addition to our written submissions.
Well, you may or may not be able to assist me, and if you can't assist me, that is fine. But I'm just curious, really. The sentence of 25 years for manslaughter appears a fairly strong sentence. And if you combine that with in what you said in exchange with my colleagues, there may not be provision for remission of the prison sentence. I'm just wondering whether the parole system was seen as a way of ameliorating what would appear to be to some people the harshness of course, we don't know the circumstances of the offense and so on, but this is a general point. 25 years, that sentence does seem to be a bit harsh. And I'm just wondering if you had any assistance you could provide me in understanding, you know, well, why that was the case and whether somehow the system of parole is relevant to our evaluating, that kind of sentence.
Much obliged, Your Honor. Unfortunately, I cannot assist Your Honor in answering the question as to the reason or the determination of the 25-year sentence. That was a criminal matter addressed by the DPP's office. However, just looking at the parole system itself, it does contemplate that it provides some relief where sentences may be excessive. Because looking at Regulation 67, it contemplates where the person has served at least 10 years of his prison sentence. So it does provide some relief for where there may be harshness in the sentence imposed by the court, at least in my view.
Yes. Okay, thank you.
Much obliged.
And this prisoner has served 18 years, more or less. Is that
My
correct?
math is not great, but he was sentenced in
2002.
2012. Sorry. He served
18 plus 2. 2 years on parole and 18 years incarcerated.
Yeah, those 2 years on parole count towards the sentence as well. So
yes,
he can serve 20 years.
20 years.
Yes, that's correct.
Yes, thank you very much, Ms. Tucker.
Much obliged.
Ms. Mendes, is there anything you wish to say?
Yes, Your Honors, may it please you. Just to provide just some further information that I have received during the break with respect to some of the questions that were raised. He was admitted at the prison on March 21st, 2001. He is scheduled for release in 2027. And then in the documentation, it says that his earliest release is August 1st, 2019.
2019?
2019 is the earliest release. If I'm not mistaken, that speaks to when you are able to apply for remission. I might be wrong, but I think that may be related to remission, the earliest release.
Well, that's 2 years ago.
Yes.
And as I understand it, he hasn't been given anything that speaks to why he was not eligible for remission. Well,
no,
I haven't seen anything.
No, we haven't seen anything. And to be fair, I would not have engaged the topic of remission just yet. In that sense, I just wanted to make one last point with respect to the relief. Your Honors, I do agree that, properly speaking, I don't think that this court has the jurisdiction to determine parole. But really the matter before the court and the question before the court is really one about what is the effective remedy for this particular violation. If released, I don't think that that's equivalent to saying that this court is ordering parole. We are not also intending to we have not made any submissions about the sentence itself. Full disclosure, what it is that we want him to go back on parole and for the circumstance to revert back to the time where his parole was improperly revoked, so that he would go back on parole. That I think that's the highest case, at least for now, that we have been making and that we seek to make, particularly with respect to the time that has lapsed. I don't know to what extent we can be considering whether there's any particular risk, any other of these factors before this court, especially if my learned friend has not presented that evidence. We are not in a position to present that evidence. the parole board was fully entitled to present whatever concerns it would have before this court. And in fact, if there are any risks, those can also be attended to through variations of conditions or anything in that vein. So it's not equivalent to making a decision on parole, really, even though it does engage a review of the decision that has been made. And I do think that it should bear in this court's deliberation the fact that it's until now that we finally get some sort of admission that natural justice principles are applicable to these proceedings. And so to that extent, there has been some unnecessary resistance to this case. In addition to the fact that we sent a letter giving the parole board the opportunity to put things right and to address any of these concerns that might have been raised or that might exist, as my learned friend has said. But there has been, quite frankly, a lot of inertia on that end, and just simply very adamant position that he did not have the right to be heard. And then in addition to that, that there was a clear breach, and that therefore all of these other considerations that we attempted to bring to the fore, which is that the main question when we're talking about parole is a risk to public safety, for instance. Again, all of those things were consistently resisted. And so now we're here. I don't think that it is equitable for my learned friends to be raising concerns about all of the other factors that are relevant right now, when I think that those could have been attended to much earlier. And even now, information about that could have also been brought to the fore, and none has been brought to the fore. And so it is in those circumstances that our position is that for this particular violation, and the point at where we are, the most effective remedy for this violation is that he be released. That he be released and put back on parole, we have no objections to that. But to revert to the position before.
What you want us to do is to quash the unlawful incarceration and the decision of the board taken without natural justice, which Indeed. Automatically render him back to where he was before those irregularities were visited on him.
Precisely, Mr. President. That is what we are seeking before this court, in addition to damages. But those would be our submissions in response, Your Honors. Obliged.
Yes. So in your view, it's too late now for the parole board to rectify the situation, because you didn't ask for the case to be well, you didn't ask for us to require the parole board to consider the case. So I presume that is not amongst the remedies that you would seek at this time.
No, that is not a remedy that we would seek, simply because we don't think that would effectively remedy this breach, considering the conduct of both parties.
Yeah. Okay, thank you.
Thank you. Thank you, Your Honors.
Yes, thank you very much, Ms. Mendez. Well, we would take time to give our decision on this matter, and we would let you know when our judgment will be delivered.
Obliged, Your Honors.
Ms. Thomas Roberts, you may close the proceedings.
Thank you, President Saunders. Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnathli. Thank you, Mr. Justice Burgess. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.